Hi everyone, Joe Gentili from Sarraf Gentile LLP. I'd like to bring everybody's attention to a new case that just gotten taken up by the Supreme Court. The case is called Loper Bright, and on the surface, it doesn't look like something that would have much to do with immigration law because it involves commercial fishing and really nothing to do with immigration. However, it can have a tremendous impact on immigration law because the issue that's really at play in that case is a concept called Chevron deference. And Chevron deference basically stands for the proposition that as the law stands right now, this is a very simplified version of it, courts will, or the judiciary branch in general, will give deference to administrative agencies for administrative agencies to interpret ambiguities or kind of missing pieces of statutes or regulations. So what that means in the immigration context is that if there's ambiguities or kind of little missing pieces in immigration law, courts will generally defer to the agencies, USCIS, ICE, CBP, the immigration courts in terms of having them decide how to interpret them. So this current case that's pending before the Supreme Court is expected to have a very strong possibility of overturning the concept of Chevron deference, which means that instead of the agencies getting the kind of final say to interpret these ambiguities, the courts will now. So this can be a very, very big change for immigration law, depending on what the case finally looks like, because from the positive perspective, there's going to be a lot of issues that previously were not able to really be addressed effectively through litigation that now may be effectively addressed through litigation. So if you have a presidential administration that is, let's say, hostile towards immigration, and their agencies want to set priorities in a way that are anti-immigrant or against the rights of immigrants. Before, while Chevron deference was in place, that presidential administration would get a lot of deference in how they interpreted statutes and regulations. But if Chevron is gone, then the courts are going to have a much bigger say. And so immigrants or people fighting to get positive interpretations of these regulations or statutes will have a better chance. Chevron deference covers a lot of areas, all areas of administrative law, and a lot more than just immigration. So if Chevron deference goes, there's areas of the law and the administration of the government that I think will be negatively impacted by that. But the bright side and the silver lining is that at least in immigration law, I see the possibility for some positive changes in the rights of immigrants if Chevron deference goes. So it's a little bit scary, and it's a very exciting development at the same time. So stay tuned and keep an eye on the Bright Loper decision, because it could change a lot of things. If you have any questions, please feel free to reach out. And as always, I hope this video was useful, and I encourage you to subscribe if it was. Thank you.